It's their fault you bounced a check.
No.
It's their fault your bank did, ma'am.
I'll just
Ma'am.
try it.
No, you won't. We're gonna handle this as I want.
Well, whatever you want to do. I don't know what you want from
I want you to stop interrupting me. That's what I want. Listen to me. You bounced a check.
And I
Ma'am,
understand.
let me finish. You bounced a check, and that clearly, when you bounced the check, triggered all these other events. It triggered them charging late fees for 5 months.
And I had no idea until March.
That was your fault. Why do you blame them that you bounced a check? That you wrote? You keep listen to me. I want to listen, but you keep interrupting me.
Morning, Your Honor. Marlena Schoen for the plaintiff, P69505. I'm appearing for the attorneys of record.
Ma'am, did you listen to and understand the rights on the video?
Yes.
Do you wish to apply for funding or talk to a lawyer?
Countersue and also do a jury trial against them. I'm not a lawyer. One, I do not owe this, and I've reached out to them repeatedly. I have proof of that. They are targeting and harassing me and threatening.
Slow down. Just slow down.
So I work midnight, so I'm really tired.
Okay. Well, that's fine.
Okay.
I have to believe there's a triable issue. I'll be glad to talk to you here.
Okay.
Ms. Sean, why don't you tell me what the total amount is that's due on this?
$175 they're suing me for.
Hang on a second.
I'm happy to, Your Honor.
Oh, okay.
I'm happy to, Your Honor. So just to make a statement first, we have a payment of $554 that we're holding because it's a partial payment. And the co-op does not accept partial payments. So the total amount, $552 in arrears, $225 in late fees, and that includes also a NSF check fee, and then $179.04 in our court costs, for a total of $956.04.
Is that less
Moore,
the 575?
Your Honor, once the 554 is applied, so we don't apply and this is a co-op, they don't apply partial payments. So if a partial payment is made, they'll hold the payment, but they don't apply it. So once the 554 is subtracted, then she will owe approximately $400.
40204.
402. So, Your Honor, just to be clear, there was an NSF fee that took place in October. It was October 17th. 552 was returned for insufficient funds. There was a $25 fee that was assessed and a $50 late fee. Because the $25 fee and the $50 late fee were never paid, she's then had late fees every month. So so
let me stop you a second. Let me stop you. Ms. Moore.
Yes, Your Honor.
Now, wait a minute. I want you to just take a step back a second. They had to file a lawsuit. They are therefore entitled by law to their court costs and their statutory attorney fee, which amounts to $179.04. They're also entitled to late fees. How much do you cap your late fees at?
Your Honor, the late fees are $50 per month, and then there was and there were a few months where we didn't charge her late fees at all. So she was charged the NSF $25 fee, and she was only charged 4 late fees, even though she was late for October, November, December, January, February, March, and April, which is 7 months. She was only charged 4 late fees.
So just take off your combative hat. Okay, just take off your combative hat for a moment. And I'm not sure why they're not. Why does the co-op not accept partial payments when it's for non-payment of rent?
So, Your Honor, they have a policy of not accepting partial pay. So they have a large ownership and membership, and they don't accept partial payments because it's a board policy. I'm covering this case today. This is not my case. I can't get into the reason behind it. I'm not sure what the reason is, but they do have a policy against accepting partial payments because I think once people start to make partial payments, they feel like they've. So here's the thing: if she had paid the 554, then she would have, if we'd accepted that, she would have been current on her carrying charges, but not the late fees and not the
Well, you
other
have the
fees.
right to come in and get a judgment for the remaining balance is my point.
I
I don't
understand, Your
go-
Honor. I'm covering this one, so I can't go into the reason that the board made this decision, why this is part of the rules and regulations. If you want a testimony on that on another day, I could certainly provide that.
Testimony. I just think it's okay. Okay, so sit back a second. What part of this do you disagree with? You got to pay the late fees, you got to pay the court costs. And I don't see any way how you don't know 40204 unless you can tell me, and you're gonna have to spell it out clearly, but just take off your angry hat for a second, okay?
So I want to take a step back. Back in October, right? They're saying back in October about the check fee, correct? I just received in March of this year, them addressing me. That's one issue.
Wait a minute. Wait. Slow down. What do you mean you just received in March them addressing?
They just sent me,
Well, did you have a bounce check in October or not?
I did,
Well,
but I didn't have late fees. There's more to
ma'am,
this.
ma'am, if you bounce a check, that's your fault.
Correct.
That's actually illegal to write a check with not insufficient funds in the account, particularly when you know that.
I didn't know.
Well, you can't write checks if you don't have the money in the bank.
Right.
So they had a check that bounced. And therefore, once that check bounced, you're accumulating late fees.
I have, well, let me back up and say, I requested them to send me the rules and regulations
Why are you fighting?
because I don't owe. I have.
You don't owe?
No.
You don't know the filing service and statutory attorney fee? You don't know late fees? Come on.
If I came to court for a jury trial, if I showed you what I have,
Good. You're gonna bring it next week. You're gonna bring everything, you're gonna get it all put together, and you're going to calculate for me. Right now, you're not winning.
I understand that, and I'm not a lawyer.
Well, I know, but if you bounced a check in October, who's at bigger fault? Them for not telling you you bounced a check until March?
I bounced.
Wait, you're interrupting. Who's more at fault? Them for not telling you or addressing the fact that you bounced a check in October until March? You not knowing that you bounced the check, or you writing the check when there were insufficient funds in the account?
The day that they notified me that the check was.
Doesn't matter. You bounced a check.
Right.
They're entitled to the NSF fees.
I'm not, well.
What part are you complaining about? I'm not sure what you're complaining about. You tell me exactly what you owe and exactly, you heard what she said.
Right, so.
Wait, I want you to listen to me. I want you to tell me what you owe exactly to the penny. That's a wonderful thing about math.
Yes.
It's not subject to interpretation. There's no lawyers advocating, well, that it should be more money or less money because no.
Okay, so.
Tell me exactly what you owe. That's the first thing I want to hear out of your mouth.
That everything to you, the $175 in late fees, they're saying that I owe.
They say you owe $225, and then she also said for 7 months you were late, and it is $350, and they're only charging $225.
This is all new to me, the paper that they served me, all this additional stuff, I can prove, I didn't get, this is being thrown at me. I contacted them. I said, I have recording, time, state, date to prove I paid this on time. They sent me a threatening email that they're gonna charge me with felony charges, that they're gonna add on charges, and I have proof I don't owe these. I have proof. So if you wanna know what
do you owe?
what I owe, out of the 175,
What do you mean out of the 175? You got to tell me what you owe. She thinks you owe $956.04 less $544 that they're sitting there with the check that they haven't cashed. They think you owe $402.04. They didn't say about 401 or about 600. I want you to tell me exactly what you owe.
so back in October, the resignation.
I don't want to hear that.
Oh,
I don't want to hear that right now, please.
I paid
Ma'am,
everything
ma'am,
you want me to say.
so you think you owe zero?
Absolutely. And I can prove it.
Good. Here's what you're gonna do.
Oh.
You're gonna put this, first of all, I want to finish your rights. You did listen to and understood the rights, right? Right? Yes,
It's never right to report trial.
ma'am, just listen. Do you want to speak to a lawyer? Do you want to speak to a
Yes, I
lawyer?
do want.
Okay,
I just got this paperwork last week. I just got.
hang on. You're talking, doing a lot of talking. We're gonna give you the number of Lakeshore. You can call them. I don't know if they've cut back funding. They used to show up here every week. You're welcome to call. And speak to them. You're welcome to hire your own lawyer. You are welcome to hire your own lawyer. You are welcome to apply for funding if you don't have the money.
Oh, I don't, I'm laid off.
I want to know. First of all, I want to tell you, I think you guys are wrong for not taking that. You can tell your board that. I don't know why they're making up such a rule. I really don't. Not on non-payment of rent cases, but you're going to outline both.
Trust me.
Let me finish, man. You told me a minute ago you owed 175. Did you not say you owed 170?
They're saying I owe 170.
No, they're not. They're saying you owe 40204 plus they haven't cashed the $544 check. Are you calculating when you calculate all this, the filing fee, the service fee, the statutory attorney fee, and the NSF fee? I just have a feeling you guys are going to end up back at square one.
This is what they sent me for today.
What's this? I don't know what this is.
What they're suing for me. They're adding stuff on today that I've never heard of. So you're asking me and they're coming at me with stuff that I wasn't even aware of.
Well, they're entitled to.
Well, they're adding on charges that are not.
They said rent is paid through February 28th on the complaint.
I paid March and I paid April. They won't take it because of the late fees they're trying to add. I don't owe late fees. I called them. I offered their attorney proof of that. They won't talk to me. They won't email me. They've been harassing me. I went to the board last year and.
Why are, hang on. Did she pay March and April that you didn't cash?
Just give me a second, Your Honor. So she made a payment in March of $552. I'm happy to have. I can let the board know that they should apply the $554 payment. We can do that, and so that leaves the amount that we discussed. And again, it's just the court
Pay for
costs.
April. Did she pay for April?
It looks like she submitted a money order for April. That was the one that has not been applied yet, but I can have them apply that.
Was the one applied for March?
Looks like there was a payment applied for March.
But if you read the emails from them, the harassing me and threatening me, honestly, if you've seen everything that I have, the last 2 years, I've had to refuse phone calls and take emails because they wouldn't even email me. I just received last summer the name of the management company they would not give me, which I have emails documenting. I have a perfect record, I used to work for Trenton Schools. I managed the JV hockey team. I have a son home from Iraq who's in Detroit Cop. I have another son in the Marines that's about to be deployed. I requested in the email to them, please certify mail because at any moment when my son gets his orders to deploy, I haven't seen him since last year. They refuse to do that. They want to catch me when I'm not home. Last week, I just got this in the mail. I work midnights. Had I been gone to see my son and they know this, I would have never known about this court date today. I've asked, please just communicate with me. I have several phone calls, emails. They will not.
Slow down. Why are they saying, why is somebody filing a complaint dated March the 31st saying that rent was paid only through February 28th? If you're telling me they applied the rental payment for March?
So, Your Honor, so when a payment is made, it's applied to the earliest balance. So when 552 is made for March, she still owed a partial balance for February. So she didn't pay all the way. So
They
she,
did.
Stop, ma'am. You're in a courtroom now. You gotta stop interrupting. Let her finish. Go
so
ahead.
just, so Your Honor, just, so when a payment is applied to a ledger, the payment goes to the earliest charges first. So the
Makes sense to
earliest
me.
charges would be the NSF charges, the late fee charges. So she still did owe partial for March, and she was not paid in full through March when we filed this case because of these other charges. And
You're
that's why.
saying even after applying the March rent, she had rent due of only 175, correct?
So 175. So yes, Your Honor. So 175 plus the 50 is the 225 that we're alleging is remaining owing right now, less the 554.
Say that again.
So the 175 plus the 50 is the 225. Right now, all she owes after the 554 is applied is the 225, which is the late fees, which is essentially the late fees and that NSF fee, plus the
How much is the NSF
179.04.
fee again?
It was only $25, Your Honor.
Okay.
So what she owes is
I have a
NSF.
feeling that you're so wrong on this, man, but I'm going to keep an open mind. You want to put everything together? No. I don't know why you're blaming them that you bounced a check and they didn't notify you for 5 months. You should have known that the money wasn't in your account when you wrote the check. That's number one. Number two, your bank would have notified you. I don't know why they didn't. Go call them. Number three, when you bounced the check that caused all these other payments to be applied to October, that's why you've got the late fees. I mean, this is pretty clear with me. I don't know why it isn't you. I don't know why it isn't clear with you. That's what's happened. When you bounced the check in October, they didn't say, well, you paid November on time, you paid December on time, you paid January on time, you paid February. No, they were applying those fees to October. Now, I'm going to give you a chance. You want to put everything down, but tell me every copy of every check that you wrote and when you wrote it. Okay? I have a feeling that they're right and you're not, but I'm going to give you an opportunity.
Am I able to request something?
Yeah, if you don't interrupt me, yes. Go ahead.
I emailed and asked for information from them.
What?
I wanted my file. I moved in there in 2019. And I asked also, if they would send me, I have the email, but they won't send me copies of anything I've asked for.
Well, they're entitled to charge a reasonable copying fee.
I mean, they didn't even say that. I asked if they would email. I have the emails, they won't. I had to go to the board last August.
Ms. Schoen,
Shall
do you have, do they have any policy on copying? It should be a reasonable copy fee.
this,
Ma'am, I was just talking to her. Did you not see?
you said Shelley? I didn't.
Well, I didn't say Shelley. No, I said Ms. Schoen, I think. It was
You did,
clear. I
right.
was looking at her. Do they have some kind of policy with regard to copying?
I'm not sure, Your Honor. I'm covering this one today for my friend. But I can certainly find out. Is there something that she needs? And perhaps I
Wants
can
everything since
provide it to her.
19. How many pages do you think that would be, Ms. Moore?
Well, I wanted to know, one, if I had any
I
violations.
didn't ask you that.
Okay.
How many pages do you think that would be?
2 pages.
2?
2 pages.
Oh.
3 maybe?
Okay.
Documents.
Since 2019?
Yeah, because can I tell you what I asked?
Yeah.
I asked for my file. I wanted to see if there are any violations, because I shouldn't have any.
Well, what does that have to do with anything? Why does any violations have to do with anything? They're not terminating the tenancy for cause here.
Yeah, they're trying to get to me.
No, they're trying to evict you because you haven't paid the rent. So that is not really relevant. Whether or not you've had a violation, if you're talking about some rule violation of the co-op, I don't see anything in here. Did they allege that you violated rules?
In the email, that's why I.
Well, but that's not the subject of this suit.
budget request, from 2019, they'll let my payments, because I have discrepancies on dates. So I don't know if they can give me a copy of that. And then also I wanted a copy of the pest control, and I've been asking that for over a year.
Pest control.
We have a cockroach infestation and a mice infestation, and this is why they've been targeting me, because I've been speaking out about it.
Is that true, Ms. Schoen? Has she been making complaints about that?
Your Honor, I'm covering this case today.
So whose case
I'm
is
not,
this?
I'm not aware. This is Pentiak, the Pentiak firm. She's asking questions that don't have anything to do with this case. If this were a termination case, I would have all of the answers for all of the background for the termination. If you'd like me to look into whether there's
I'd like you to send the lawyer that's in charge that represents Southwick next time. If they're claiming, if they're targeting her on this, and that's what she's alleging at least, I'm not saying that they are or not. I want some answers here. But in order to tell me, ma'am, that you owe X amount of dollars or don't owe anything, and I hope you're at least keeping an objective mind here.
I am, it does look bad.
If you missed a payment in October, that means you should have been paying late fees for October, November, December, January, February, March, and April. Now, if they're refusing to cash your check and then charging a late fee, but that doesn't appear to be the case. It appears as though you were late. Even after they applied the March one, you still owed 175. And if you owed 175 plus 225 in late fees, that's 400 plus $25 in an NSF fee. If anything, they might be shorting themselves.
Can I speak for you out of it?
No, I want you to just calm down. Yes, Ms. Schoen.
Your Honor, so I think what would be helpful from my perspective would be to have the client appear. So I routinely do coverage work, sort of counsel work for this firm. So we could, if we have the client appear, they could respond directly. Having an attorney appear doesn't mean they're going to know all of the claims.
Why don't you do that? We'll adjourn it a week. What time do you have for me, Jen?
We can do 10:30, Your Honor.
April 27th?
Yes.
Defendant to bring complete breakdown.
What date is that? What day is that?
A week from today?
Oh, Monday?
Yeah. The defendant to bring complete breakdown of payments made / why she doesn't owe money. Please just don't come in here and say they're harassing you and there's an issue with pest control. Come in here and give me a sheet. These are the dates that I've made my payments. These are the dates that the charges are due. This is why I don't owe the late fees. You can file a little brief.
Am I able to submit video too?
About what?
I have proof. I videoed me making my payment, because all we have is the Dropbox. So they can say whatever date they want on here, and I have proof, timestamp, dated, and recording of every month.
Well, you guys are really going out there, huh?
Because you don't know what I've been going through. You don't know what I've been going through. You think I want to be here? No.
Your Honor, may I?
Yeah, Ms.
I'm sorry, Your Honor. I have a 10 o'clock and two 11 o'clocks on that day. Is it, or 8:30 possible, or 9 o'clock perhaps?
I'll do 8:30. It's going to be easier for her too, because she works midnights, right?
Okay. Okay, so 8:30 a.m. And Your Honor, if I have a client with me, is it okay if I appear, or do you need, because the attorneys at the firm, it's really the client who would have this information, not the attorneys.
I don't care who appears, honestly. I just need some hard
We'll have the client
facts.
appear. Thank you.
That's fine. You can appear. So I need you, and I have a feeling, and I don't know how to explain myself other than to say that I don't need to see videos. if you think there's a discrepancy on late fees because they're saying they didn't get it till the 12th and you paid it on the 8th, I'll be glad to look at your video. Have video, you could just put in parentheses. And then if I need to see it, they're telling me, Judge, we assessed a late fee because we didn't receive a payment till the 12th. And you're telling me I have a video here that shows that you paid it on the 8th, sir, then that's fine. But I don't need to see videos.
I'm sorry, can I ask one?
Did you hear what I said?
Yes.
So you're going to tell me exactly to the penny why you don't owe any money. Okay.
I did get one question. So I just want to ask you, so in in October, on the 31st, they put something in my mailbox or in my door stating about the bounce check. So on October 31st, that same day, which was Halloween, I went and got another form of payment and paid October.
I thought you told me that you didn't receive anything from them telling you about the bounce check until March.
Fines. They didn't send me anything on how much I owed them. They sent saying my check didn't go through.
They sent that to you when?
October 31st.
I thought you told me earlier. I'm going to go back and listen to this tape. Wait. I thought you told me that they didn't send you anything until March to tell you that you bounced a check in October. You didn't say that?
Fees. When they sent.
No.
Fees.
Wait.
They weren't charging me nothing.
Wait a minute. I thought you told me they didn't notify you about the bounce check until March. Am I wrong?
The bounce check fees until March, which I have. Because October 31st, they put something in my door.
Saying that you bounced your check.
So I went and ran and.
So you realize October rent would have been late when you put that in there October 31, right?
I'm sorry, October 31st.
I think that's what you said. You said you went and paid it right away, right?
For the second time, because the first one, they just notified.
No, you didn't pay it for the second time. You paid it for the first time because the first check bounced.
Correct. So October 31st.
Then when did you make your November payment?
They're all in time. November on time, December on time.
Okay, you're going to write down every date that you gave me, that you made your payments. I'd like to get this by Thursday. Can you prepare this by Thursday?
Yes, I have to work tonight and then.
I don't need to know when you have to work. Can you do this by Thursday? Yes or no?
Yes, I'll have it to you before then.
Okay, take your time. I want it done well.
Can I?
Did you hear what I said?
Yes, am I able to give you everything that I have? Or I mean.
We're here to talk about non-payment.
Okay.
That's what we're here for. That's why they sued you. They didn't sue you because you violated a law or a regulation or rule of the co-op. They're not asking me to terminate tenancy. All they're saying is, Judge, make her pay up. And if she doesn't, we want an order for an eviction after 10 days from the date of the judgment. That's what they're going to ask me to do. But the pest stuff, I don't need to hear about right now. I have a feeling you guys are so close on this.
Am I able to, how to sue that? Am I able to you?
Do whatever you want. You got to follow the court rules. I'd strongly suggest that you talk to a lawyer. Talk to Lakeshore. Explain the whole situation to them. I'm not going to give you advice here. I would call them today. We will give you their phone number today. Okay? And then you can talk to them and you can follow the court rules and you can do whatever you need to do. But this is for non-payment of rent, which is a lot different than some of the things you're talking about.
Well, I was confused because I paid rent every month and when I emailed
You
them.
didn't pay rent every month. You didn't pay.
The late.
I'm just surprised you're now telling me that you didn't know about the bounce check until March, but paid it October 31 because then they notified you, but didn't notify you about the $25 NSF fee.
So October 31st, it stated my check bounced. So I ran and got a money order. There was no fees in that, nothing. 5 months later, I'm receiving.
Well, if you paid November 1, December, January, February, March, April 1, then they shouldn't have been charging you any late fees, assuming in big letters that your balance as of October 31 was zero. They're not taking that NSF fee, counsel, let me just be clear about this. They're not taking that NSF fee of $25 and proceeding to charge her with late fees the whole time on every month because she owed $25, are they?
So she owed $25 for let me just look at the ledger for a moment, Your Honor. So she owed the 25 for the NSF fee. She also owed a late fee for October. She didn't pay the NSF fee or the late fee for October. And then she made a series of other payments
When did she make her
later.
November payment?
November payment was made on the 8th.
That's within the time frame for the late fees, right?
It is. And
And
then
then when did she make her December payment?
the 10th.
That's before, I think it says the late fees don't
Goes
kick
through
in
the
until the
10th. I
11th,
believe
right?
yes, I believe it's the 10th. And then
What about
February,
January?
January was the 10th, February was the 10th, March was the 13th, I believe.
So you would owe late fees
And
for March.
It was paid on time.
Well, it's not really paid on time. It's paid within the late.
I paid that before. That's not the right date. That's
Okay.
March.
No, I know, but your rent's due the first. You've got a habit of paying it on the 10th. Why? That's your question, but go ahead.
so, Your Honor, I think she first said that she was not notified about the insufficient funds check until March.
No,
She's now changed
Yeah.
the story and
but
now
what she's saying is
acknowledged
that
that
on
she was.
October 31, and I get it now, she wasn't notified there was an NSF check fee.
So the ledger is available at any time. She can walk into the office and get a copy of her ledger.
Here's my
The
point.
NSF.
Here's my point. Why don't you call up? There's something that's not sitting right with me. Can you get your client to zoom in now?
I can't get them to zoom in now, no. But I can. But if we come back on the
Why can't they zoom in
27th
now?
at 8:30.
Why can't they zoom in now? Because I want you to make this clear to them. If they didn't notify her of the the $25 late fee, then she, according to what you're telling me, I think, was up to date by the end of October. In other words,
She still had a
She'll-
late fee as well
from what?
from
October.
October, Your Honor, because she bounced the check, so she had a late fee from October plus that fee.
Okay. And she never paid for the late fee in
No,
well,
no,
listen.
she didn't.
Listen. This is like, so she owed a $50 late fee, and now you guys are tagging her, as far as I can see, for a late fee for November, December, January, February, March. Another late fee could have been added in March. And then you're holding her money for April and charging a late fee there, right?
No, so Your Honor, we're not. So we only charged her 4 late fees, even though they were entitled to receive 7 late fees. She was late for October, November, December, January, February, March, and April, since she never paid the NSF fee or the late fee. So they only charged her 4 late fees instead of the 7 that they
Is
were
this
entitled
really
to
why
do.
we're still here? You owe some late fees, young lady, Miss Moore. You owe some late fees. Okay? But I'm not going to let you compound because she owed a $50 late fee and a $25 NSF fee. I'm not going to let you charge her.
Would the court
I
like to make
see
a
what's
ruling
happened
today?
now. Now I see what's happened. What's that?
I'm just wondering if you'd like to make a ruling today, Your Honor, if you've come to a conclusion about how you'd like to rule, or if you want us to come back on the 27th.
You want an opportunity to file a counterclaim? Do you want an opportunity to put together your figures? Listen carefully. Please listen carefully before you make your decision. I'm not going to require you to do anything. Just listen carefully. If you didn't pay your October payment until October 31, you owed a late fee. I now see the problem. You owed a late, so let's forget about the NSF fee for a second. You bounced a check. So you owed $50 in late fees in October, November, if they're supposed to compound, if it's reasonable for them to compound, because you owed the $50 late fee for October in November, December, January, February, March, and April. So that's 7 months. They charged, how much is the late fees? 50?
50, Your Honor, yes.
And you told me that you had late fees of 225 because that includes the NSF fee, right?
Yes, we have 4 late fees of 50, Your Honor, plus the 25. And that's
Clearly,
essentially half of the
I
late
know.
fees that they were entitled to charge.
I know, but that's, you know what, that's a little over the top, don't you think? Let me tell you this. You want to file a counterclaim, talk to a lawyer, I'll give you a week. It seems to what should happen here is you still have to pay the $179.04 in court costs. And you still have to pay the $25 NSF fee for a total of $204.04. You want to go talk to a lawyer, you want to file a counterclaim, do all that, that's up to you. But I can, if you want, rule on the number of late fees that I think is reasonable in the face of this. And go from there and enter a judgment today, whatever you want.
Can I just say one thing? I sent them an email, I got laid off. And I sent them an email saying, I'm getting laid off. Can you waive, any,
Man, they don't have to do that.
No, you're right. What I'm saying is I was trying to communicate with them, but they won't communicate with me.
Well, I'm going to communicate for them. I'm going to make a rule.
Can I come back?
You can do whatever you want. This is the United States of America, the greatest judicial branch anywhere in the world. Do you want to come back? You want to fight with them? That's okay. That's okay. Because I don't like a couple of things they did either. I don't like them telling people they can't make partial payments. I don't know where people come up with that. There's nothing in the law that says you can't make a partial payment on a non-payment of rent case. So for boards to take action different than that, I have a fundamental issue with. But you were wrong too, and you don't think you did anything wrong, and that's problematic too.
They sent an email stating that they give, the first time you bounce a check, they'll waive it, right?
Ma'am,
I'm just saying they sent an email to me. So this is the first time I bounced a check since living here since 2019. And like I said,
never bounce a check.
you're right. One time since.
Ma'am? Okay, let's stop because I've held this up enough. These lawyers are probably upset with me and they have every reason to be because I've been on this case for half an hour now. If you want me to make a ruling today, I will do so. If you want to go talk to a lawyer and file counterclaims and do all these other fun things, that's up to you. AI is not always I will. I know people get pleadings off of AI, they have AI help them and whatever, but you still got to think on your feet. You got to know what you're saying. But whatever you want. You want me to adjourn it? I'll adjourn it. Is that what you want? Okay. But do you get what I'm saying? So you disagree with anything that she said in terms of when you made your payments?
All my payments have been made on time.
No, they haven't. Not one of them. Not one of them.
Not October.
Not one of them were made on time. What time's the date say that you have to make your payment, counsel?
They're due on the 1st, Your Honor. I believe they're late on the 10th.
Right.
So at the end of the 10th.
I think the 11th, right?
Yes. So they're.
So you're not making them on time.
So
You're making them in accordance with the contract to avoid late fees. Please don't leave here thinking your payments are on time. You wouldn't pay your mortgage company 10 days late, would you? Not unless you want a 312 credit rating.
they said it's not late.
Ma'am?
It's paid by the 10th. I'm confused, so I don't know.
Well, it's pretty clear. The contract reads you're to make your payment by the 1st. You're making them by the 10th. Because the late fees kick in on the 11th. Doesn't mean you're on time.
But I don't get no late.
Doesn't mean you're on time, though. You're saying you made all your payments on time. You didn't make one of them on time.
Well, there shouldn't. be-
Did you hear what I said?
Yes, but I don't understand.
Okay, well, let me do a better job of explaining.
Do they,
The contract says your payments due on the 1st. If you make them on the 10th, you might not have to pay late fees, but it's still late. Do you get that? Listen, yes or no?
I'm trying to read what's in here with the contract that they, with.
Ma'am, ma'am.
Not late.
Does the lease say, we know it's not late until the 11th. I've said that 4 times. We know that. It doesn't mean it's timely if you pay it on the 10th. It means you can't be assessed a late fee. But she just explained clearly to me how you accumulated these late fees. Do I agree that because somebody's late or somebody didn't pay $50 that they should be able to accumulate a bunch of late fees? No. But you bounced the check, you caused this, I'll let you go take care of it. You can write everything down. We're going to come to the same conclusion. I know I am.
You know that.
Ma'am, I don't need to hear anymore. I know you didn't have to pay late fees because you paid on the 10th. Don't leave here thinking that you pay on time. You don't pay on time. You've never paid on time, according to what she told me.
I have proof I have before the 10th. That's what I mean.
No, on the 1st, you have proof that you come in here and you prove that any of these payments you're telling me weren't put in on the 10th. If you can prove to me that they were paid by the 1st of the month, in which case you were on time, or earlier than the 1st, in which case you were on time. But let's not debate this. April 20th, April 27th, 8:30, you can bring me in something, you can show me. I'd like your client here. I know I'm going to reach the same conclusion, but go consider your counterclaim, talk to the lawyer, figure out what you want to do, and go from there. We'll see you next week. Thank you.
Thank you, Anna. Just have one more.
Yeah, I'd rather have you here. Honestly, I'd rather have everybody here if you want my honest opinion, but Southwick versus Robin Rogers, 2601544.
Good morning again, Your Honor. Marlena Shum for the plaintiff, P69505.
Good morning, Ms. Rogers. Your name?
Oops, I'm sorry, Robin Rogers.
Did you listen to and understand the rights?
Yes, sir.
Do you wish to speak to a lawyer or apply for funding?
I would like to apply for funding through some state assistance programs.
Good enough. So here's what I'm going to do. You have the right to apply for funding. You should do that. And you should bring proof that you've made your application for funding within 5 business days. So get it up here by Friday. I'm
Friday.
going to adjourn this until May the 4th. At what time, Jennifer? 1 o'clock?
1 o'clock, yes.
At 1 o'clock.
Do I
So
just
we're
bring
going to
my,
adjourn this for 2 weeks.
Okay.
May the 4th at 1 o'clock, and you can provide proof that you've made you have to provide proof that you made your. Beth. Williamsburg Square versus Kaya, Washington. Actually, not yet. Tell her about 15 minutes. Williamsburg Square versus Kaya, Washington, 2601082.
Good morning, Your Honor. Andrew Smith, P64541, appearing on behalf of plaintiff Williamsburg Square Apartments.
Good morning, Ms. Washington. Your name?
Good morning, Kai Washington.
All right. Where are we with this?
Your Honor, this is our 3rd hearing for non-payment rent possession only. Ms. Washington did apply for rental assistance. My understanding is that was our first hearing was on March 23rd when she applied for the assistance. Our second hearing on April 6th, now today being the 30th. I encourage her to continue. She said she's still trying to get that done. But at this point, we are going to ask the court to enter a judgment or a hearing on a judgment, the amount owed.
Why don't you give me your breakdown, if you would, please?
Yes, Your Honor. The total due and owing as of today.
Rent to retain, let's start with.
Rent to retain, $2,577.
Late fees.
Late fees total $225 over the course of 4 months.
All right. And that's in addition to the 2577.
Yes.
All right. What kind of service and filing and attorney fees?
Bailiff and filing fee comes to $100. $1.54 plus a $75 statutory attorney fee. So $176.54.
All right, what's the total?
$2,978.54.
Ma'am, do you owe that amount?
Yes.
You haven't heard anything from the funding agency?
No, I reached out to them because I haven't heard anything this previous week, and I left voicemails. They told me to leave my contact information, and I still haven't yet heard back.
Are you going to be able to pay this?
Um, I can make a partial payment sometime
I
tomorrow.
don't know what you mean by partial payment. How much?
Um, maybe a couple hundred by tomorrow.
Got to pay all of this within 10 days, man. Counsel, I'm going to give you a writ date of April the 30th. I need that this morning, please. If defendant pays $1,600 by April 30, writ date extended until May the 4th. I'll do that for you, okay? That's the best I can do, ma'am. So you're either going to have to pay all of it by the 30th, or if you can't, you can pay $1,600 by the 30th, and that will buy you until May the 4th, okay?
Okay.
I wish you well. Good luck, ma'am. Mr. Smith, what other ones do you have, sir?
Your Honor, I also have Marion Manor versus Jennifer Scott.
Marion Manor versus Jennifer Scott, 2601191. Your appearance?
Good morning, Your Honor. Andrew Smith, P64541, appearing on behalf of the plaintiff, Marion Manor.
Is Jennifer Smith here? I'm sorry, Jennifer Scott. Yes, there you are, ma'am. Can you turn some lights on there, please, so I can see your face? And then tell me your name.
Oh, sorry. My name is Jennifer Scott.
Okay. Can you turn some lights on there? You look like
Yeah.
a kind of a, there you go. All right.
Okay, so
Have you heard from the funding agency since you were here on April the 6th?
I did. I got approved from my work, Henry Ford. I don't know the amount yet. I have a call back to St. Vincent's and United Way on Wednesday to see the process there. And like I told the attorney, I do get paid again on Friday. I did drop off $850 today. So
Do you, did she submit, Jennifer, her proof of application for funding within 5 business days?
yes, I did. I have that from your court.
Yes, Your Honor. It was dropped off on the 9th.
And that is to what agency?
Do you want me to answer? I'm sorry.
I
Either
was
one
going to say,
of
I've
you.
got to pull the actual document up.
Tell me,
Judge, so it's
ma'am.
just taking
Tell
me
me
a
who
second.
you applied with.
Henry Ford, the Michigan state of Michigan, St. Vincent's and United Way and Detroit Housing. 2 of them probably weren't on that form at that time, but I did have 3 of them on there.
And you've heard from who?
Henry Ford. They went. I don't know the amount yet. That's my employer. And then St. Vincent's, I'm calling back on Wednesday again to see how much or how we go through the process.
I'll adjourn this 2 weeks. Are we doing May the 4th or 5th, Jennifer?
Judge, we can do the 4th, but we would be in the afternoon.
At 1 p.m. May 4th at 1 p.m. Okay? So, ma'am, if you don't have the money, then I'm going to have to give them a judgment on that date, okay?
Okay, thank you.
I wish you well. So make sure you make your calls and get all your money together, please. Thank you. Any others, Mr. Smith?
Just one more, Your Honor. Hamptons of Brownstown versus Reuben Plummer Jr.
Hamptons of Brownstown versus Reuben Plummer Jr., 2601186. Mr. Plummer, good morning. Your name?
Reuben Plummer Jr.
You got to get a little bit closer to your device and keep your voice up. Can you tell me your name again, please? Mr. Plummer, I need your voice, your name
Yes, it's
again.
Reuben Plummer Jr.
Good morning. Mr. Smith, your appearance?
Your Honor, Andrew Smith, P 64541, had a chance to meet with Mr. Plummer regarding this second hearing non-payment rent. Mr. Plummer is applied for rental assistance, indicated he's in the process and waiting for a response from DHS.
Did you already make your application?
Yes. Actually, mine was through Merrill Lynch. It's approved and they're processing, so I'm basically just waiting on them to send a check out.
What do you want to do, Mr. Smith?
I'm okay if you want to adjourn it to the 10 days or whatever your feasible next hearing date is. Is it if April 30th?
Do it next Monday if you want, or I can go to the 4th.
I'd rather avoid digging into May because I don't want to just
Got it.
more.
What do you have on April 27th for me, Jen?
9:30.
I'll adjourn this to April 27th at 9:30. Merrill Lynch, you must be talking about taking out money out of your retirement account or something, right?
Correct.
That is an actual application for funding. Did you fill out an application for funding?
Yes.
With who?
Well, no, I went through my 401k to get the.
So that's not really an application for funding. So you're not really entitled to adjournment, but I'm going to give you another week, okay? April 27th at 9:30. You got to get on the horn though and get them to get you your money so you can pay your rent timely, okay?
Okay.
All right. I wish you well. Good luck. Thank you.
Thank you.
That's all I got, Your Honor. Thank
I
you.
need that. Have a good day. I need that sentencing. Sentencing I gave you.
Yeah.
Oh, I thought John had it.
You want better or not?
No. I'm gonna take this other set on. Kyle Alexander Ellis, 25B1495548, A and B. Where's Mr. Ellis at? Where's
He's
Mr.
joining
Ellis at?
He just joined.
You have to call them.
Mr. Ellis, your name?
Hi, Judge.
I need you to take your hat off and tell me your name, Mr. Ellis.
Kyle Ellis.
You need to take your hat off, sir.
Oh, I'm sorry. I could barely hear you, so I have to put this up to my ear.
I don't know what I did on this one. Why are you coming in so late?
So I don't have a license and it's hard for me to get up there. I tried going up there on the 7th. I believe you weren't there, of course, my luck. And then
April
I've been
7th?
trying to see you
Hang
on
on.
Zoom.
Hang on.
Okay.
April 7th was Tuesday.
Or was it the 7th?
What time did you come in?
It might have been the 17th. I
What
forgot
time did you
what
come
day
in? What time did you come in?
It was early in the morning, like 9.
You were supposed to pay 100 a week starting April the 6th.
Oh, I
You
didn't
paid-
know I
you-
was already on a, I'm sorry, payment
Are you-
plan.
Mr. Ellis,
Yes.
come on. I told you to come and talk to me on or before the due date. I give you credit for at least showing up later, but you haven't come close to making this payment. Time to pay in accordance with the schedule. Where do you work at again?
So that's the thing. I paint with my cousin and we're doing pressure washing as of right now, but we just went back to work last week. So that's why all the little money I had, I did pay some already. I know I haven't been close to it, but that's but I
How much do you
literally
have
just
today,
started
Mr. Ellis?
I just paid 2 days ago $45.
$40.
And I get paid again Friday.
When can you pay this?
So is 100 a week? I could pay 100 on Friday or the full thing.
I'll let you pay 100 per week. We'll make it April 27th. So if you get paid on Friday, you don't have to rush up here.
Okay, awesome. That would be awesome. I could do 100 a week.
Starting April 27th, and then you have the other charge to pay, okay?
Yes.
So I'm going to say 100 per week on the misdemeanor, 48A, beginning on April 27th, and then 100 per week after fines, costs paid on that file.
Okay. Thank you, Judge.
All right? Now listen,
Okay.
next time you got to come and talk to me on or before the due date, okay?
Okay. Yes, sir.
All right, good luck to you. Thank you.
Okay. Thank you.
All right. People against just give me 1 second, if you would, Ms. Aycock. I'll be right with you, okay? I'm going to take yours next.
Thank you, Honor.
People against the Adriana Giselle Vajegas. This is file 26W84031. All right, your appearance.
Good morning, Your Honor. Leslie Aycock, on behalf of Miss Vegas, who's present to my right. Can you please state your name?
Adriana Villegas.
All right, so your client pled guilty to operating while impaired. She was referred for a screening and assessment. Have you had a chance to review that report with her, and are there any material additions, corrections, or deletions?
Yes, Your Honor. I have reviewed it with my client. There is one addition to that report. Since the date of the report, she has picked up a second job. She maintains the employment that's listed in the report, but she's also working at a local restaurant. She works Saturday and Sundays, usually between approximately 10 a.m. to approximately 5 p.m.
What kind of restaurant? Is that a bar restaurant?
No, they do serve alcohol, but it's Mom's restaurant there on kind of Fort Street and West Road in Trenton.
Okay. Okay. Okay.
Yeah, aside from that, the report.
Is there any
my
other
client-
bar or restaurant? Is that the only one she works at?
That is correct. Her Monday through Friday, her main job is in Livonia. She
Right.
works at Total Spectrum as listed in the report. So
Got
this
it.
is just a second job she picked up to assist her in paying attorney fees and fines and costs related to this offense.
Okay, good enough.
Other
Any,
than that, she indicates it's factually accurate. There are no errors or omissions. We would ask that the court adopt the recommendation. The only thing that I would ask is they do recommend a number of days to be on the court work program as ordered by, Your Honor. I would ask that the court consider not sentencing her to court work simply because she does work 7 days a week currently. And that is, like I had indicated before, as a result of the expenses related to this offense. So we would just ask that the court consider that scheduling issue for her. Other than that, we would ask the court to adopt it. We do have one further request regarding travel. She
Okay.
is scheduled to travel with the court's permission on May 1 of this year through May 4th. That's Friday through Monday to Virginia. She is attending her cousin's wedding. She'll be flying out on Friday, returning by air on Monday, the 4th of May. She'll be staying at her aunt's house for this family wedding. And we would ask for permission for her to travel on those days.
okay, young lady, is there anything you would like to say?
Yes, Your Honor. I made a mistake and I've learned from it. And I thank you for your patience. I know I've had a lot of adjournments with the discovery, so I thank you for your patience with this, and I apologize for my mistake.
Okay. The only thing that concerns me here is the extent to which, look, you're young, you're 23. You were just able to start drinking 2 years ago, right? That's the law. And you got a really high breathalyzer here. I mean, you're over two times the legal limit, 0.172 and 0.175. So you got to be careful. That's the only thing I have concern about. And you've been going to AA once a week?
Yes, Your Honor.
12 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. You're not to go to any place that sells or dispenses alcohol. I'll let you continue working at Mom's Restaurant. You're to submit to chemical testing, PBTs and ETGs. I'm going to make them monthly or more on demand of probation. Monthly or more on demand of probation. That's probably a little bit generous on my part. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm going to order that you attend the Victims Impact Panel, that you attend a Level 1 Alcohol Education Treatment Program, and that you continue attending AA once a week until you're in the Level 1 Alcohol Education Program. You've seen her verification, correct, counsel?
Correct, Your Honor.
Okay. So you continue doing that until you're in the alcohol Level 1 treatment, a Level 1 alcohol program. So once a week until and then, again, I want you to go in person, attend the Victims Impact Panel. In terms of fines and costs, well, first of all, I'm going to allow you to go to Virginia between May the 1st and May the 4th. You're going to serve 4 days jail credit, 1 served 3. I'll let you serve those 2 days on the court work program, 1 day of community service. 8 hours of community service is due by June the 1st. 2 days court work we will set you up on. You're to pay fines of $300, costs of $350, $75 victims' rights fee, $50 justice assessment. So your fines and costs are $775. Probation fees are $240 for $1,015. You have screening fee of $60 for $1,075 plus your court work program fees. Your total is $1,145. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand all of that?
Yes, Your Honor.
You may be eligible for early discharge. You get everything done in 6 months, stay out of trouble, no violations within the preceding 90 days. By statute, you're entitled to early discharge. You can make application for early discharge at that point. Do you understand that?
Yes, Your Honor.
All right. Can she pay all of this today or does she need time?
She'll need some time, Your Honor. She can pay $260 today. She said she can stop by the courthouse after we finish here. And
Meet
then,
with probation. Try to go meet with probation so they can instruct you. Okay, go ahead.
and then she could pay $300 a month. She may be able to do more, but I think $300 just to be safe. A month thereafter, we would ask that she be given till May 20th to make her next payment.
Tell you what, I'll make it 125 bi-weekly and she can start that on May the 22nd, okay?
Thank you, Your Honor.
And if you ever need more time on any of your due date, if you don't have the money, that's not a problem. Just call the court. We'll go on Zoom on or before the due date, or you can walk up here on or before the due date at 8:30 in the morning. I'll be glad to give you an extension, okay?
Thank you, Your Honor.
Thank you
Good
very
luck
much,
to
Your
you.
Honor.
Thanks a lot. Have a good day.
You too, sir.
South Glen versus Anthony Farrar, 2601294.
Judge, I think we got a dismissal on that one.
Is that right?
Yeah, I'm just looking really quick, but we don't have it on our docket any longer. So I believe that we just missed pulling it out.
Would you just double check on that and I'll recall it? South Point Square versus Shelley Moore, 2601543. Is Shelley Moore here? Come on up here, ma'am. Did you listen to the video?
Yeah.
Come on up here to the podium, please, and tell me your name. All right. Good morning, Ms. Schoen. Your appearance?
Good morning, Your Honor. Marlena Schoen for the plaintiff, P69505. I'm appearing for the attorneys of record.
Ma'am, did you listen to and understand the rights on the video?
Yes.
Do you wish to apply for funding or talk to a lawyer?
Counter sue and also do a jury trial against them. I'm not a lawyer. One, I do.
I was gonna see if we could do the 21st on that Tuesday.
Let me ask you a question. Are those in the morning?
On the 14th, Your Honor?
Yeah.
Yeah, they're all in the morning.
Well, I could, Lisa, is there a reason we can't do it at 1 o'clock on the 14th?
Let me double check.
Oh, wait, I'm so sorry, Your Honor. I see it's scheduled for the 14th at 11. As long as it's okay if I'm possibly just like running a little bit late or it goes to the like 12, that's fine. If it's the afternoon, no problem at all.
Judge, you have an afternoon flat rock docket that day.
You think this one's likely to go?
Yeah, I do, Your Honor. But again,
Let's
with
do it.
11, I can
hang
probably
on.
swing 11.
Are you sure? Because what I don't like is I don't want people showing up at 5 to 12 and I've got a 1 o'clock docket. I want to get out of here for an hour and I certainly want my staff to.
Yep.
So if I can either give you, I can either give you 12:45 on the 14th. Or I can do 1 o'clock. I mean, I guess, yeah.
Oh, 12:45 works perfect.
12:45, July the 14th. That's when I'll make it. Okay.
I appreciate you very much. Oh.
That's the day you have the afternoon flat rock docket.
No, I know, but he's going to be here right and ready to start at 12:45, right? The docket doesn't start till 1. This won't go more than half an hour, will it?
No, I don't believe so. And I can even be there at 12:30 or earlier, to be honest.
Okay, good. We'll make it 12:45. Try to get here early, talk to the prosecutor, and we'll go from there, okay?
That's perfect. My sentencings are in like Livonia, so they're close enough for me to get there, no problem. So
okay, great. Thanks.
Just always. Thanks, Your Honor. Great to see you.
You too. Secure Express LLC, 26S118475.
Morning, Your Honor. Ali Barrow, P85907, appearing on behalf of the defendant. Requesting his presence be waived. I do have permission to enter a plea on his behalf.
All right, you're authorized to enter this plea on the behalf of the company to Overweight, correct?
Correct, and to a reduced fee to $6,000, 30 days to pay, Your Honor, or get an
On
appeal.
behalf of the company to the charge Overweight, responsible or not responsible?
Responsible, Your Honor.
Plea is accepted, $6,000 paid by July 31. Thanks.
Thank you, Judge. Have a great day to you and your staff as always. Bye-bye.
You too. Thank you. Bowija Clinton. This is 2-6M680000.
Morning, Your Honor. Brian Kelly on behalf of the defendant.
Are you the football coach that used to coach at Notre Dame? I'm just kidding. Where's Mr. Clinton at?
He's here. He's here remote, Your Honor. He's on. I think he's turning his camera on. We've had an opportunity to speak with the prosecutor, and I think we would be able to resolve this. But I believe we're going to need an interpreter, French interpreter, so I can get through a couple questions and probably the advice rights.
I'm surprised. I arraigned him. I'm surprised I didn't.
And I thought we were going to be okay with after we went to the arraignment, everything went fine. And when I was talking to him today, I realized to get through it, it's probably going to be a little more clear for
Get a French interpreter. Mr. Clinton, can you tell me your name?
My name is Bouija Bashiga Clinton.
I'm going to set this for July the 14th. And we're going to get you an interpreter. What time are we doing on this one, Lisa?
10 o'clock.
At 10 a.m. Okay, counsel?
Thank you so much, Your Honor.
Have a good day. Good luck, sir.
Did you say French interpreter? I'm sorry, French?
Yes.
French, please.
Okay, thank you.
July 14th. Thanks.
Thanks. Mr. Clinton, we're all set. Have a good day.
Mohammed Alamara, 260-816-656. Mr. Walls, I'm going to ask you to take the cigarette out of your mouth, please. I know thank you. Where's Mohammed Alamara?
Right over here, sir.
Your name? Tell me your name.
Mohammed Alamara.
Does you have a fishing license? They're dismissing. In the interest of justice. I love that, huh, Mr. Graziani? In the interest of justice.
Thank you.
Dismiss motion of the plaintiff. You're all set. Prosecutor, good luck.
Thank you very much.
Hussein Asarov, 26D816657. Where is Mr. Asarov? Good morning, sir. Your name?
Hussein Al-Saraf.
We're adjourning this 2 weeks so you can get a license.
Yep, sounds good.
July 14th, what time, Lisa?
Any time works for me.
Well, good. Thank you. I was asking my judicial clerk, but we do want to
9:45.
accommodate all participants here.
Okay.
Okay, go ahead. Go ahead.
9:45.
Okay.
9:45.
9:45.
Okay. Good
Okay.
luck to you. We'll see you then. Thank you.
Okay, thank you, Your Honor.
All right. Have a good day. People against Griffer. Ryan Joseph Griffer, 26B711925.
Good morning, Judge and staff. John Graziani, I bring on behalf of Ryan Griffer, who is to my left. Please identify yourself, sir. Ryan Joseph Griffer. We're seeking a 1 week adjournment, Judge.
Lisa, who is sitting for me then?
Judge Hessen is handling all PCCs.
Yeah, so I'm not going to be here. So I'll tell you what I'll do. Can you call Ms. Holloway?
There's a bit of an issue, Judge.
No, I get it. Call Ms. Holloway a second. I could adjourn the final pretrial to July the 14th. Here's what I'm thinking. And then set the trial for the following.
That would be great, Judge.
Let me just check and make sure she doesn't have any conflict with witnesses or anything like that, okay?
Absolutely.
So I'm going to ask her, conference room machine. I didn't get a sheet.
I just called her. I didn't get a sheet either. She's on her way in.
Did I ask your name, sir?
Yes.
Okay. Just give us 1 second here.
What do you got?
I thought Ms. Holloway was on this one.
Yeah, Miss Holloway.
Yeah, what conference room is she in?
Oh, fine her. Yeah. She's in the, I already know where she's.
I can go get her. She's in the room.
Is she in the two?
She's in the room across the hall to me.
Yeah, Ms. Esmeralda, I don't need you on this. This is a domestic. I just want to make sure.
I was gonna say, I haven't talked to Attorney Graziani to the case yet.
What's that?
Talk to Attorney Graziani.
I'll be talking to you.
Yeah.
Let me talk.
What are you doing here? Can I hand this to you, please? You.
She's on it.
I can go grab them.
Yeah,
Thank you
please.
so much. It works out well. Just
How you doing, Ms. Holloway?
Yeah, the people, 86528.
You didn't show up. What time did you show up today?
9.
What time we start our dockets?
I know.
It's okay. It's fine. Try to get her early. I went. It's all right. I was impressed with this young lady trying her bench trial. I don't know if she did. Why are you shaking your head side to side? You did a very nice job.
Oh,
It's what?
top 5.
Yeah, but she did a nice job on this. I was really impressed, Mr. Graziani.
that's why I don't want to go to trial.
I know she's tough. She's going to be a really good lawyer. I'm impressed. I'm not easily impressed
It's a
either.
good prosecutor's office.
Okay, so I'm thinking about taking he wants to adjourn the pretrial 1 week. I'm not going to be here, so I'm going to adjourn the pretrial 2 weeks and adjourn the bench trial from July the 14th until the 21st. I want to make sure that's not going to create a problem for you.
That works.
Okay, so we'll make it July 14th at, we'll just make it at 9 o'clock. Bench trial on the 21st, Lisa,
At 1.
at 1. Okay? All right, I know what I said. You did a nice job. I was impressed. Good luck, sir. We'll see you here in a couple of weeks. Thank you. Lucas Bowman, 26 709-278P.
Ready, Your Honor. Good morning. For the record, Trevor Garrison for Mr. Bowman. Your Honor, we're respectfully requesting an adjournment of the pre-hearing conference.
You guys can't, what are they doing here? It says pre-formal officer stated a case was submitted to prosecutor for misdemeanor charge.
Exactly. That's right.
Well, I mean, I'm not going to wait for them to go through that. They either need to. Oh. I don't know. Did you talk to the prosecutor about this, Mr. Garrison?
I did.
What is she saying? Have they submitted it? Are they going to authorize on some misdemeanor charge or what?
Well, I don't think she knew that it was that the civil infraction was dismissed. I told her that, and so that's another reason why we're requesting the postponement. I don't believe we'll be able to resolve the civil infraction anyway. They're indicating that they have no authority to dismiss it, given that my client had a CDL. A dismiss or amend. So it's likely it'll go to formal hearing.
Well, I'm going to adjourn the formal hearing then. I'll set it for, we'll set a formal hearing. So you have to be in person though, okay? July the 14th at what time, Lisa?
Well,
I'm not going to put this off much longer. I mean, I get it. I'm not saying I'm a fan of that law, but that's the policy they take. So.
No, I understand. I'm out of town on the 14th. Do you have any other days besides Tuesday? My Tuesdays are jammed for the next few weeks.
This is a state prosecutor and they're only in here on Tuesdays.
Okay.
I'll go to the 21st. That's the latest I'm going.
Well, but I'm going to be in Bradenton, Florida anyway on that day. I'm sorry.
You said you weren't going to be here on the 14th.
Right. And I'm also gone the following week. I'm in Colorado on the 14th.
Are you really going to have a formal hearing on this? I mean, if I get guys telling me this, then they come in and plead and, I'm not going to. I don't want to do that. I'm just telling you, if I'll go out of my way to set this later for you, if you're really going to have a hearing, but guys don't have hearings on these.
Well, I mean, my client, this is his livelihood. I mean, having a.
No, listen, I don't, I'm not, if you're going to have a hearing, all you got to do is, no, Judge, we're definitely going to a hearing.
Right. Well, I mean, yeah, we have some dash cam. And that's a decision I'll talk to my client about. But
all they got is 70 to 65. I just can't adjourn it much longer, is all I'm trying to tell you.
I understand, Your Honor. Well, I mean,
what day can you do on a Tuesday? I'm not taking it to August. I promise you that.
Well, that was what I was going to suggest, August 18th, but.
No way. No.
Okay. Well, then,
I can do an afternoon for you. I'll do that for you. Where's your office at?
Royal Oak.
I can't go that long. What's wrong with, you're going to be gone the week of July 14th and the week of July the 21st and the week of July the 28th?
No, not the 28th, but the first 2 weeks, yes. How about August 4th in the afternoon?
What's that?
Is August 4th in the afternoon?
Why can't you do the 28th?
I have a pretrial in Oakland County Circuit Court in person at 8:30, and then I have a Clinton Township matter at 1.
Call in the prosecutor, will you? And you're gone for 2 weeks on vacation or what?
No, the first week is well, kind of. The first week is a vacation for 3 days, and then the next week is a soccer camp in Bradenton, Florida.
Well, so I got it. You play soccer or your kid? You mean?
No, my daughter does.
I'm not going honest. I can tell you that. So you're gonna have to figure out something.
Well,
counsel your appearance.
Good, morning, Your Honor, I'll take this 9.5. The people be 800.
I don't want to adjourn this forever. He wants me to set it for August 18th. I'm not going there. This is the civil infraction, 11 to 15 over, but they only wrote them for 5 over, right? They only wrote them for 5 over. This is.
Is that the one with $60?
Yes. Yes.
And you were already made aware that that question was dismissed because it was going to be submitted as a misdemeanor in the law. This.
Count 1 was, right?
Yes, not 2.
Right.
It's a CDL driver, but it's a CDL driver. I did let defense counsel know I can't use it anyways.
That's still limited access, right?
Does it say limited access on there?
It doesn't say limited access, but they never say limited access. This must have been, they wrote them for 70 and a 65 on I-75.
Yeah, they wrote it as they wrote it as exceeding speed limit. Those ones are tricky. They don't give us much room to do anything.
No, I know because of that masking law, which I don't know why they.
I don't like it.
I'm not blaming the prosecutor's office. At first, I thought maybe it was them, but it's not. I read the masking statutes, and I don't know.
Well, if I have a strong opinion on that.
I don't, yeah, but she can't violate laws. She's not going to do that. They're not going to do that.
No, I understand. It's neither here nor there, I guess, but it's just, I don't think it prohibits plea bargaining. It's just masking I think it's different, but that's for, I guess, another day.
You can reduce the charge to something similar. So non-moving violations can get reduced, but moving violations are not allowed to get reduced unless it's something similar. So if I had like an 11 to 15, I could reduce it to like a 6 to 10 or something.
And they only wrote them for 70 to 65. I'm not sure why the jacket, unless somebody made a mistake, Lisa, says 11 to 15 over.
It was a mistake. I can assure you, we have the dash cam. That was a mistake.
Well, wait a minute. Well, I'm saying an internal mistake by us because somebody put on the register 11 to 15 over. They only wrote them for 70 and a 65.
I could see that, yeah.
I don't know what the actual speed was. They usually put it on here. They didn't.
It said 70 and 65 right under the ticket, under the portion with the charge, under the count.
That's what they charge, 70 and 65.
Right, and exactly. And
but I don't see what the actual speed was, unless it's saying he was only going 70 to 65.
It was going 70 to 65. Typically, when I see speeding tickets, sometimes they'll put 72 and a 65. The numbers will change. It doesn't stay to that 1 to 5 range. It doesn't stay to that 5 range.
Right.
I believe he was going 5 over.
I don't know what to tell you guys. I'm not adjourning this talk. So,
all right, if you know what, I have another thought. If Your Honor, could I join the breakout room again and I'll talk to the prosecutor? All right, thank you so much.
Yeah, sure.
Thank you.
Thank you. Transport. Amex Transport 26S 118-447.
Respectfully, Your Honor, Sam Richard Dollar, P62186, appearing on behalf of Amex Transport with the authority to enter into today's plea agreement.
Good morning, Mr. Jadal. This is going to be a plea to overweight. Fines and costs $7,000, correct, and 30 days to pay.
Yes, Your Honor.
All right, you're authorized to enter that plea.
Yes, Your Honor.
Is that charge of overweight responsible or not responsible?
Responsible, Your Honor.
Plea is accepted. Fines cost $7,000, paid by July 31. Okay.
Thank you, Judge.
Thanks a lot. Have a good one. Becker.
You and your staff also.
Aaron Michael Becker, 26M702004. Where is Aaron Michael Becker? Aaron Michael Becker, you need to start your video and state your name. There you go.
Becker.
I don't have Trooper Zagalonis out there, do I?
Hold on 1 second, Your Honor. I gotta roll my windows up and turn the truck off. All right, I'm here.
Is Trooper Zagalonis out there, Lisa? I don't see him.
No, he's not.
You're a winner today, sir. The officer failed to appear. Case dismissed. I gave him 15 minutes. It's now 10:06 and this was scheduled for 9:45. Slow down a little, please. Your record doesn't look that great. I know it's a prohibited using
Except my record
handheld,
don't
but
look great.
don't be doing that though. You know what I'm saying? That's dangerous. I see. Well,
Yeah,
I
hey,
didn't
Hunter,
look
so-
that closely. I just saw some citations on here. Let me see here. No, it doesn't look that great. I mean, no, it doesn't. I mean, you haven't had anything since 22. That was a hazardous action. Just be careful. No use of cell phones, okay?
Yes, John, and I just want to let you know I am a truck driver. I use a headset while I'm in the truck. That day, I just picked up the phone the moment he drove by in my personal vehicle, and I apologize.
Have a great day. It worked out for you. Good luck. Case dismissed.
Thank you. Have a good day.
Thank you. Mohammed Kari Otba Benaziz, 26 M653046. Where's this gentleman at? There you are. Your name?
Mohammed Ben Aziz. Hi.
Trooper Reem, your name?
Mohammed Ben Aziz.
No, I heard you. Trooper, your name?
Trooper Nicholas Ream.
Can you just get a little closer to the device? He's got a clean record. You wrote him for careless. It says traveling at speeds in excess of 90, weaving in and out of traffic. Do you want to offer anything here?
Yeah, I'd like to offer 10 over.
Do you want to plead to 10 over, sir? That would be limited access 80 and a 70, and that would be 1 point.
Yes.
You want to plead to that?
Yes. Yes. Yeah.
To that charge of 80 and a 70, responsible or not responsible?
Responsible.
All right, I'm going to accept the plea. Fines and costs here are $155. You can go on 33court.com and pay that today, okay?
Okay.
Have a great day. Thank you.
Thank you. Thank you.
James Allen Kennedy. This is 6G 703768.
Morning, Judge. Jason Kazmarek for James Kennedy.
Good morning, Mr. Kazmarek. Your name, sir?
James Kennedy.
You got to get a lot closer to that device, please, and keep your voice up. I can hardly hear you. State your name again.
James Kennedy.
All right. So, counsel, does he stand mute and waive formal reading for purposes of the plea, of the arraignment?
Yes, Judge.
And now, as I understand it, you met with the prosecutor. Your client's going to plead guilty to operating while intoxicated, first offense, with the super drunk charge to be dismissed. True?
Sort of. I would actually like to plead a no contest for my client.
Why a no contest plea?
It's been a liability.
Was there an accident?
There was, and there was a couple injuries as well.
There was injuries to people in the other car?
And his own, yes.
All right. She didn't.
No, I didn't. Yeah, I don't know if we talked about it. We talked about it over email or talked about it previously. But
the police report in here.
I can highlight some things on the police report. I don't know what your court requires as far as no contest, but I mean I can certainly provide the factual evidence.
Hang on, see.
Not Denali's office. Just gonna see.
Can you bring in the police report on James Allen Kennedy, please?
I'll do that, Tom.
Thank you. I don't care if there's possibility of civil litigation. I have no objection to that. I'm going to have to get the police report in here. You heard me call.
From that night.
What's that?
So the memory from that night isn't great either, to be honest, Judge. He had a bit to drink.
Where's your office again, Mr. Kazmarek? I'm going to need the police report.
In Monroe.
Contest, please.
Oh, I can't do no, I wouldn't do non-contest for that.
He said that your appearance.
Good morning, Your Honor. As you guys remember, people be 193. Typically, we only go contest almost production to go over by. But is it easy saying you can't remember?
Wait a minute, keep your voice up for the record here.
Oh,
No, he's saying there's a possibility of civil litigation. That's what his lawyer said, that there was an accident.
car accident, yes, that's correct.
And that there were injuries to somebody in his car and or the other car. Both of them sounded like, right?
I believe so.
That's correct.
So why would you have a problem with that?
Typically, we don't do no contest, but that's fine. We can get
The court rule forbids me to do it, so I can be the bad guy. So
said you need the police report.
I need the police report. If you don't have a paper copy, you're gonna have to send it to Lisa. I'm gonna go aside from this and okay, thanks. Lisa, I can send John down there when you get it, okay?
Okay.
Herman Elijah Morissette, 267-707-301, A and B. Sign an advice of rights form. Yes, you did. Okay, your name?
Herman Morissette.
So this gentleman, you met with the prosecutor, right?
Yes.
I arraigned you. You met with the prosecutor. She's offering you the opportunity to plead guilty to allowing an unlicensed driver to drive and the speeding 1 to 5 over, with the understanding that the no ops charge will be dismissed and the careless driving charge will be dismissed. Is that your understanding? Is that how you wish to proceed?
Yeah.
If you plead to 1 to 5 over, that's 1 point. But you're getting the 3-point violation dismissed. If you plead to allowing an unlicensed driver to drive, that's 0 points and it won't go on your record. And that is a 0-pointer punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form here today? If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that?
Yes, Your Honor.
All right. You have the right to a lawyer. I told you that before. I'll tell you again. Do you want a lawyer?
No.
To the charge allowing an unlicensed driver to drive, how do you plead?
Yes.
To the charge 1 to 5 over, responsible or not responsible?
Yes.
I can't hear you.
Yes.
You plead responsible or not responsible? Were you in control of a 2008 Chevrolet silver in color that was being operated on June 9 to 26 at 6:53 p.m. On the ramp 226A near Sibley Road in Brownstown?
Yes, Your Honor.
Did you allow somebody to drive that was unlicensed or suspended or revoked, and was that you?
Yes.
And are you on probation or parole?
Yes.
Were you on probation or parole on June the 9 to 26? Probation or parole? To what court? On a felony?
Yes.
You understand by pleading guilty, I'm just telling you, this could be deemed a violation of that probation. That probation could be revoked. You could be incarcerated on that charge as a result of this misdemeanor plea and conviction. Do you understand that?
Yes.
You still wish to plead guilty? Anybody in the world force you to plead guilty?
No.
Plea is accepted to allow an unlicensed driver to drive. I'm dismissing the no ops, accepting the plea to 1 to 5 over, dismissing the careless. I'm ready to sentence you. Are you ready? Anything you would like to tell me before I sentence you? You don't have a valid license. Wait till you get your license that's suspended.
I've been going through a payment arrangement.
I'm sorry?
Payment. I've been going through the court payment arrangements.
What courts?
36 districts.
Anything else? 100 fines, 75 costs, 75 victims' rights, $50 justice assessment, 300 or 60 days. Do you have all that with you today?
Pardon, would you say that again, Your Honor?
$300 or 60 days, and I'm going to charge you $150 on the speeding. So you need $450. Do you have all that with you today?
Not right now. I'll do it in 60 days.
Where do you work?
G and F. I mean F and G. F and G's.
Can you pay anything today?
I just really started really last week, and it's a 2-week every period. So the 60 days will be fine. It'll be actually partially up to 250. So it's 450. I just started really last week.
I'm going to have you pay the $150 on the speeding by July the 24th. Can you do that?
Yes.
I'm gonna have you pay the $300 on the other case by August 21st. Can you do that?
Yeah.
If you don't have the money, there's no reason to be scared. Just call the court. We can go on Zoom, or you can walk in, Your Honor, before the due date at 8:30, and I'll be glad to give you an extension. Fair enough?
Yes.
Good luck. Thank you.
Okay.
Yeah.
Let me see what it's is written and find out.
Sure. Sadie, good luck. Do you have the police report on that one yet, on Kennedy, Lisa?
Yes, I'm printing it right now.
Okay. Hussein, I'm sorry, Nashu Hussein, 26B 711-738.
Good morning, Judge and staff. John Graziani on behalf of Mashoud Hussein, who's to my left. Please identify yourself, sir.
Mashoud Hussein.
Judge, I've spoken with the prosecutor, and we've agreed to adjourn for 3 weeks, but there's a separate issue. Apparently, Mr. Hussein would like to represent himself. I have no problem with it. He's not hurting my feelings. If he feels he could be better, I have no problem.
What law school did you go to?
Oh, it's going to college.
Yeah, I know, but what law school did you go to?
I didn't go to law school, Your Honor.
You think you can do better than him?
It's not that I can do better than him. It's just that the case has been going on for so long.
It hasn't been going on that long. Listen. We started the case, you were arraigned on May 22nd. It's been going on for 5 weeks. Well, listen to me, sir. I want you to listen to me. You can represent yourself if you want. I don't know why you'd think you could do better if you went to Macomb County Community College. No disrespect intended whatsoever. It's more than some people do. This guy's been practicing law for 30 years, right? 35?
I can't believe it. 35, 36 years.
He's a good lawyer.
Thank you, Judge.
This is a serious case. You got a domestic violence charge. I'm just telling you, I'd urge you to reconsider. You have the right to represent yourself. You do. Everybody does. You could be charged with murder and you could still be allowed to represent yourself. It's just, I'm telling you, as a guy who's been around the block here, you're hurting yourself by representing yourself. You don't know anything about the rules of evidence, do you? Do you know what the rules of evidence are? I could take 10 days to explain those to you. There's all kinds of legal objections that you don't know anything about, sir. There's manners in which you can and can't ask questions. I'm just encouraging you not to get rid of your lawyer. I'll be glad to give you 2 weeks, but because the case is still pending, 5 weeks later means nothing to me.
It's just that, like, this was supposed to be my final reach out, but then was supposed to get reach out. That's going to be last time I was in Florida. It was supposed to be a final reach out, and just this time has been going on. And I don't have a place to live right now. I'm living off a hotel. I pay $500 a week.
Where
at? Days in Morning. I'm from Sterling Heights, and I don't live on this area. I had a home, and I lost my home. And while facing through these battles and tough times right now, in the process of going to forward of my home that I'm living in, I'm about to be evicted. And I don't even live at that home. So in this case, that where it's the other victim's not here, it's not showing up. That's why I'm like,
who's the victim in this case, Mr. Graziani?
It's an ex-girlfriend.
Is she living in the house?
She was. She was living in the house. I suggested to him that he could move in, with permission from the court. However, it appears that everything's been shut off and it's basically a little, without any water, Judge. It's pretty bad from what I understand. But for the record, what Mr. Hussein.
Hang on one second. Can you staple this and mark this P? You're not helping by getting rid of your lawyer and representing yourself. Let me be blunt about it.
Understand you.
So why don't I do this?
It's just that I think the judge speak. I'm trying to figure out what my final pretrial is, and I'm trying to understand that the victim isn't coming here.
Well, I can make him come.
Yeah, I understand that, but it's just that.
Call him Ms. Holloway again, John.
Good. I'm trying to understand that, like, this issue is, I'm trying to have it resolved. I'm trying to get back on my feet, go to work. I can't go to work. I don't have my car. I don't have a home. I don't have a place to live.
Have you guys conversed with the victim on this case involving Mr. Hussein?
Yes, Your Honor. As of yesterday, I believe I spoke to the defense. She's still cooperating.
That means she wants to proceed.
He wants to get rid of his lawyer. This makes no sense to me. Here's what I'm going to encourage you to do. I want the victim here at the next pretrial, okay? I'm ordering her to appear. I'm setting this for July the 14th. At what time, Lisa? 9:30 or something?
Yes, 9:30.
Just to clarify, are you ordering people to send out a subpoena?
Yeah, I don't care however you do it, whether you call her, tell her the judge wants her here on July the 14th at 9:30. But if she doesn't show up, I'm going to entertain a motion to dismiss. Now, I'm going to encourage you to keep your lawyer for the time being. You're not helping yourself by getting rid of your lawyer, okay? You're making it worse. Do you understand that? Now, if you want, since you seem to be in a hurry, if you want, I can set it for trial today too, for another day. I'll be glad to do that for you.
Is that the final pretrial?
Well, I'm going to have a final pretrial in 2 weeks, at which time the victim has to appear. And if she doesn't appear, I'm going to dismiss the case on motion of your lawyer. You can also set a trial, whether a jury or a bench trial, 4 weeks down the road or 3 weeks down the road. So if you guys want to entertain that, either a jury demand or a bench trial, but he wants to get rid of you, so maybe you don't want to make that decision.
Judge, I feel uncomfortable at this time.
Are you willing to keep your lawyer through the next pretrial?
Is that in 2 weeks, in July 14th?
Yes. I'm not going to be here next week, so I can't do it next week.
Yeah, that's fine.
If you want, I'll get rid of your lawyer. You're making a big mistake.
Yeah, that's fine. I would like to have representative.
You want him to?
Yeah.
July 14th, 9:30. We'll see everybody here then. Thank you. Charles Bejuan Boyd. Two 6W706997.
Good morning, Judge and staff. John Graziani, appearing on behalf of Charles Boyd. Judge, we had the opportunity to review the precinct.
Your name, sir?
Charles Boyd.
Okay, so I'm sorry. Go ahead.
Judge, we had the opportunity to review precinct report. There's no additions, deletions, or corrections. We are asking, however, that a no contact order be lifted. We have evidence that shows that his daughter contacted my client. And
where's she at?
Currently?
Well, no, I'm asking, is she here, Lisa Tahari Boyd?
Oh, not on Zoom.
Judge, she's not here. We do have evidence of text messages from her, which indicate that she wants to move back with Mr. Boyd. And
well, I got to have her here to tell me that. I can adjourn the sentencing a week or two and 2 weeks and have her.
Judge, if we,
I can have probation call her. I mean, I'm not gonna look at text messages that she sent him without her being here and lifting a no contact provision, whether it's part of a bond or part of a sentence.
Judge, if I may, if we could possibly adjourn this matter simply for an hour. It was adjourned before. It was our understanding that parties would show up. Unfortunately, she hasn't shown up. I think transportation is an issue where
She can Zoom, but she can't. Let me do this. I constantly am looking for the prosecutor, and I can't remember what number she's into. Do you have any idea what number Ms. Holloway's in, counsel? I mean, Lisa. I believe I need to get a hold of Ms. Holloway. I'm going to have her call the victim and tell her I want her to Zoom in.
Thank you, Josh. Thank you so much.
She's in a breakout room. I'll try to move her out.
Okay.
I'm sorry for the interruption. May I have a breakout room too, please?
With Miss Louie?
Asmaro.
Or Miss Asmaro. Yeah, sorry. Hold on.
It's okay.
Yeah, I can't get her to move, Judge. I'm sorry.
Do you know what conference?
Oh, there she
room?
is. There she is.
Ms. Holloway, can you state your name on this, please? This is on Charles Boyd.
Hi, good morning.
Your name, please?
Nora Alloway on behalf of the people, PA 6528.
This is a sentencing on Charles Boyd. He pled to attempt EV. This involved his daughter, Tahari Boyd. I'm hoping the defense lawyer is asking me to lift the no contact provision. He wants me to look at text messages. I'm not going to do that, but I think in fairness, they want me to lift it saying she requested it and messages sent to the defendant. And I have a no contact. I'm going to ask that you or the victim's advocate call Ms. Boyd and ask her to Zoom in here at about half an hour or so. And then I can address it. Fair enough?
We can do that. Your Honor, just to clarify, this one isn't my case, but I will tell the victim advocate right now to speak to her, and Natalia Asmaro can.
These days, I'm going to figure out who gets what here, you know?
That's okay. We'll handle it. Thank you.
Thank you very much. Thank you. You can have a seat, sir.
Thank you, Judge.
All right. Now, do you have that marked? All right. Recalling James Allen Kennedy, 26G703768. They came in with a big packet. I've had the whole thing marked. Counsel, your appearance.
Jason Kazmarek on behalf of James Kennedy. James Kennedy.
I'll be happy to take your no contest plea to operating while intoxicated first, with the understanding that the super drunk will be dismissed.
This courtroom session takes a serious turn as the judge prepares for a case that could soon move directly onto the trial docket. The court begins by giving the defense one final 30-day reset, but the judge makes it clear that this is not simply another delay. The attorneys are expected to use those 30 days to become completely caught up on the evidence, review everything with the defendant, and discuss the consequences and available options. The judge specifically tells counsel to go back through the case carefully, even though previous attorneys have already worked on it. The message is simple. Before this case moves forward, everyone needs to know exactly where things stand. And the judge gives an unmistakable warning that if the announcement at the next court date is that the case is going to trial, the court intends to place it on the quickest available trial docket. In other words, the time for repeatedly pushing the case forward is coming to an end. The courtroom then moves to Salvador Gomez, and this case is significantly more serious. Gomez has 3 cases pending, including 2 counts involving manslaughter and a driving while intoxicated case that is already scheduled for a jury trial. The attorneys tell the judge that everyone is prepared and that the case is expected to move forward with jury selection the following Monday afternoon. But before the trial begins, there is one important issue that needs to be addressed: photographs and videos connected to the incident. The defense has filed a motion seeking limitations on that evidence, and the discussion immediately reveals why. The attorneys explain that the case involves a double fatality fiery crash, meaning some of the evidence is necessarily graphic. The judge does not want the jury, or anyone else in the courtroom, to be unnecessarily exposed to graphic material. The prosecution explains that while some photographs and videos may be necessary to present the case, they do not want to overwhelm the jury with gore. The defense, meanwhile, asks the court to require the state to clearly explain the evidentiary value of each piece of graphic material. Their argument is that if intoxication and causation are not seriously disputed, then showing excessive graphic evidence could potentially add little to the actual issues the jury needs to decide. The attorneys also reveal that